clear. Maybe if we can,
yeah. Okay, I think the admin has sent a message in the group that Ama will reconnect shortly.
Okay.
I'm not sure if.
Okay.
So let's just give it a few seconds and then.
Yeah.
Hello, apologies. It appears that I may have dropped off.
Yeah.
Okay. We can now proceed with introducing our first speaker, actually. That is Dr. P.S. Gadosi. Dr. P.S., as you can tell by that illustrious doctor, is a specialist in artificial intelligence. He is a lecturer and deputy head of department at the Lancaster University Ghana campus. He holds a PhD in artificial intelligence and computer vision from the Beijing University of Technology and is a fellow of the Higher Education Academy of the UK. His teaching and research interests are in the application of artificial intelligence in finance, healthcare, and agriculture, and he has several research publications to his name. He is also an advocate for responsible AI and ethical issues in artificial intelligence practices. Currently, he leads the STEMR project in collaboration with the Ghana Education Service and the Kofi Karikari Inti Foundation to set up computer labs in various districts and to train pupils at the junior high school level in computer programming, AI, and robotics. Dr. Pierce will take us through artificial intelligence regulations in the EU, US, and global areas. Dr. Pierce, kindly take it away.
Thank you very much, Ama. All right, so, well, the name is Pius, always spelled Pius. Yeah. Thank you very much for organizing this. It's actually quite interesting that it's when everybody is screaming, let's regulate AI, that you're also holding this webinar. And for over the past few weeks, if you've been following on the news or anywhere else, you'd realize that major regulators have started fighting for AI regulations. And that is what I'm here to talk about anyway. You've already mentioned a few things regarding AI. You've defined AI, you said a few examples and all that. I also have a few that I would want to present. So am I able to share my screen? Okay, let me see if that works.
I should think so.
Can you see the screen that I'm sharing now?
Yes, please, Dr. Pius, we can see the screen.
Okay, all right, sure. All right, so now, like Ama rightly said, it's what I'm going to talk about are the current regulations of AI from a UK, US, and global perspective. Well, I would rather say EU, US, and global perspective, and the challenges faced with said regulation. She's already said a few things with definitions of AI, and I'm going way back into why, right from the onset, the discussion about creating artificial intelligence started. And we're looking at the fact that our intelligence is important to us. We got to a point where we felt that, okay, why don't we start looking into producing objects or machines that would act and think just like us, right? And the three major questions that we asked were that how does the human mind work? And can we have non-humans that have minds? And how do we mimic human behavior in artificial objects? So Ama has rightly given the definitions of AI. And at the beginning, it was actually quite simple, that can we have machines that will help us, or that will replace humans in repetitive tasks, or that will replace humans in tasks that will require some form of intelligence. All right, at that time, I believe that the researchers at the time did not really see what the limits of AI could be, or whether AI could be limitless or not, right? And then today, there are people that are saying that we should regulate AI. And some are saying that we should do that now. Some are saying that let's wait and see the limits that AI can reach before we start thinking about regulations. Right. So why now? And there's a simple answer to that question. That is generative AI. Now, the question is, what is generative AI? When Ama was mentioning some of the applications, she said computer vision, AI that is used in aiding healthcare, robotic surgery, in increasing agricultural yield, and all that. And those were very, very useful. They increased productivity in very, very short time, right? But then came generative AI. Now, in simple terms, when we say generative AI, we are saying that artificial intelligence that helps to create new and original content that resembles something that humans would make, right? So she gave an example of creative AI, that designs or creates art on its own. So we are in another sense, we are actually talking about AI that has talent that also develops its talent. So I've seen art from somewhere. I've seen people take selfies, right? And I say that, okay, I'm going to create an image of Bob Marley taking a selfie, or Mahatma Gandhi taking a selfie, when you know that in those days, they didn't know what selfies were, or whether they even had front cameras for their on their phones, or even if there were phones that they used, right? So you would see that these are realistic images of Elvis Presley, Albert Einstein, Mother Teresa, and Martin Luther King Jr. taking a selfie with people, right? If nobody tells you that, okay, all these were generated by AI, you wouldn't be able to tell, right? And then also we have AI writing stories, right? Using natural language processing algorithms. We have AI composing music on its own. We have AI that's actually creating new designs for fashion today, right? All these are generative. And like I said earlier, that means that it is actually thinking on its own, and given that it has seen data somewhere, it's able to actually produce and develop that talent that it's just seen from that data, right? So why do we need to regulate AI? Is AI dangerous? Is it that dangerous? Are we now scared of where AI could take us? And there are a few instances, right? There was an article a few weeks ago that a Snapchat AI chatbot allegedly gave advice to a 13-year-old girl on relationship with a 31-year-old when having sex, right? And it actually went as far as telling or teaching the user how to cover up bruises to hide from child protective services. Recently, IBM also gave an announcement they were planning to replace 7,800 jobs with AI over time. All right, so they're pausing hiring certain specific positions. Now, the fear here or the worry here is that we are allowing the giants or the people that have the money to get richer and the poor still getting what poorer. That was one concern that was raised by Geoffrey Hinton. If you follow the news, Geoffrey Hinton resigned from Google about 4 weeks ago. Now, if you know Geoffrey Hinton, we refer to him as the godfather of AI. When advancements in deep learning algorithms, most of us actually had to learn a lot from his work. And he got up one day just a few weeks ago and said that he was resigning, and his main reason was because he felt that AI was becoming uncontrollable or was becoming dangerous, right? And the reason why he gave this, well, of course, there are risks of AI or disadvantages of AI, as Ama mentioned, that there are risks of producing fake news. There are risks of producing what are known as deep fakes. People have actually produced fake videos of people committing crimes that they've been prosecuted for. In certain instances, in other instances, you would realize that there are videos of sex tapes of people that were not actually in the video, but it actually showed that this person was in that video, right? Risks of fraud, discrimination, and all that. But most importantly, it's the risk that super intelligent AI will take over control of people, manipulate people's opinions, affect general elections in certain places, increase corruption and all that. So, and that the reason is now AI, especially the ones that we are building today, the algorithms that we are building today, have reached a point where even how they learn features of any form of data is more in a black box. Like we reached a point where you can't really explain that this is how this particular algorithm is learning the features of the data that you're training that particular AI with. Right? All you know is that, okay, if I make this, if I add maybe several layers of neural networks and I make certain changes, it will give me a correct output or to give me an accurate output, right? And it means that at that level, AI has been given the freedom to operate or the freedom to try and learn and understand the data that is being given, right? All we have to do is to decide that this is the kind of data that we are trying to train an AI for, and this is the output that we expect, right? And so some of the questions that were raised, the moment Geoffrey Hinton resigned, the US actually went to Congress, and the reason was to invite the major players in the industry, the CEO from ChatGPT, Google's CEO, a few professors that are in academia that are focusing on the development of AI or AI and research, right? And the reason was because they needed recommendations on what they can do in order to start regulating AI, or some of the opinions that they wanted to seek from them, right? And the reason for this was questions being asked included, is AI advancing too quickly? Is AI moving so fast that humans are slow in understanding how AI is moving? For instance, recently Google developed a language model to help in translating several languages. Now, of course, they had data that they used in training that model, but that data did not include a language in India called Bengali. But they were surprised that their model actually started translating Bengali, and they couldn't understand how that was happening. So they had to put a stop to. It was actually more experimental, so they had to put a stop to it, right? So that there are fears in that aspect, and so at Congress, some of the possible recommendations for regulation that they gave, I think these were actually by the CEO for OpenAI, the developers of ChatGPT, that they think that it would be good to form a new agency that licenses any effort above a certain scale of capabilities, all right, and ensure compliance with safety standards. So it means that what they're asking for is that there should be a body that will start providing licenses. And in order to do that, they will have to go through some form of audits and to make sure that what people are, or what people claim they are producing is what they are producing, and what the AI is expected to do, the AI does what it's expected to do, right? So, and also to make sure that they create safety standards and ensure that AI models cannot self-replicate and self-perpetuate into the wild, so that they are moving around freely. Now, today, you have AI that can actually self-replicate and produce more AI, right? And that there's a fear that if it is not controlled, that we'll reach a point where we are going to have so much or so many systems or so many machines that control human behavior, or that control how we make our decisions, right? But this is something that was a meeting that was held by Congress just last week, I think on Thursday or so. And also, and then the EU came out with their EU AI Act. Now, with the EU AI Act, it's something that it's a proposal that they've been developing for, I think, about 2 years now. But they just released the document a few days ago. I think about 2 or 3 days ago. So it can be found online. It's 144 pages long, and in 24 different languages. It's been translated into 24 different languages. What I'm going to do is there are certain aspects of this particular act that people are concerned about, because they feel that it is too early to come out with such strict regulations, and that it might limit further advancement of the AI technology. So for instance, one aspect is its jurisdiction. Now, the EU this act actually targets both providers and developers. So people that are producing and people that are actually making use of these AI systems. And they are looking at the countries that they are coming from, and they're making sure that they apply some form of international law to the producers of AI or AI systems, all right? And also for high-risk AI projects, they need to be registered with the government. What that means is that projects that are examples of the health AI applications in health, or AI applications in agriculture, are what I refer to as the high-risk AI projects. Now, they need to be registered. Now, if you say that I have an AI model that determines whether maybe a tumor in the brain is cancerous or not, it should only be able to perform that functionality. Now, if you're going to add several more functionalities to it, then it means that you have to register, or you have to call that particular functionality, the original functionality of it, and add more to it. So every time you go through an expensive risk testing. All right. So what they are saying is that for the various EU states, they will have to carry out third-party assessments in each country, right? And there are different fees that have to be paid depending on the size of the organization that is producing this particular system. All right. And the risks that they listed out, well, the argument is that the risks are very vaguely defined. All right. They're talking about risks to the environment, democracy, and the rule of law. Now, the question is that if you say that you're producing AI that is, or if you're saying that artificial intelligence is an effort to produce machines or systems that will mimic human intelligence, then aren't you taking away basic rights to production of systems like that, right? Also, on page 70 of the Act, it says that open source foundational models are not exempt from the Act, all right? So the programmers and distributors of the software have legal liability, all right? So that is a question that people ask. I remember a student asking me a question about having maybe an AI bot, a robot in the lab that performs specific tasks and then causes an injury to a human in the lab. Who will be held responsible for that injury? Will it be the producers of that particular AI, or is that particular robot going to be blamed for it? Or is it the worker that is going to be blamed for standing in the way of the robot? These are questions that the EU AI Act seeks to address. So they are saying that producers or developers are going to be liable to anything that any AI does. All right. So APIs are banned. Now, that is also going to be a major blow to people that make use of AI. For instance, when you look at the ChatGPT, they've provided APIs that other developers can use. So you can actually integrate ChatGPT into your project. Now, if you go as far, or if you go further to make ChatGPT do something else, then it means that you are going against the law in doing that. And you have to certify that new functionality that you are going to add to ChatGPT. So what that means is that open source developers are also affected. Now, since time immemorial, people have always advocated for open source. Right? You come up with an application, you open source it, allow developers to also make changes, to customize them, use them for their own use cases, etc. But now, when you look at the foundation models or the large language models, so a ChatGPT is an example of a large language model. They are separate from open source AI components. So, for instance, if I'm in the States, so this is actually a concern by people in the States right now, that if I am an American open source developer and I place a model on GitHub, now on GitHub, I'm publicly sharing my code so that people anywhere in the world can also have access to make changes, reuse them, and all that. And it's made available in the EU. Whoever develops it would be liable for releasing an unlicensed model because it hasn't been licensed in the EU. So now GitHub, which is used globally by anybody, researchers and developers, would also be held liable for hosting such unlicensed AI model, right? And also, according to the Act, there are very large fines. You can see that individuals can pay up to about 20 million euros if they are looking at revenues that they are getting from that, and if you go against the Act. Now, research and development and clean energy systems in the EU are exempt. So The issue here is that if R&D and clean energy systems are exempt, then why do you have these rules or these regulations against other developers? Aren't you taking away their rights to also develop? Now, the EU is seeking to, or is actually looking to push for this particular act on the 24th June of this year. Once they're able to pass that, it becomes a standard in the EU, and they're hoping that it will go beyond the EU. There are a lot of them, actually. There are 144 pages. So if you get a chance, you can have a look through, and you'll realize that there are a lot of issues there. I think one of them also states that facial recognition software cannot be used by the police. I'm actually not sure exactly what the wording is, but they can't be used live or in real time. So you'll have to wait until the video has been taken and analyzed before they can actually make use of them. So with the EU Act, you would realize that it would definitely go against a few things that the US usually wants to, like open source systems and all that. And so we will have to wait for what recommendations or what regulations the US also brings up. And all these have become important, or they become necessary due to the fact that AI has become generative, and when it comes to whether you can actually explain what your AI is doing, it's become more difficult. So if you can't explain that, you can't produce it. And you can't, of course, if you are going for the license, you should be able to explain what your AI is expected to do. And if there are abnormal results that your AI produces, you should be able to explain that as well. If you can't do that, then there won't be a license given to you for you to practice. So then that brings about the topic of responsible AI. Apart from explainable AI, responsible AI is a bit more general in what they are looking for, right? And there are a few properties of responsible AI that people, it keeps the number keeps adding up, right? The different aspects of it keeps adding up, especially due to the fact that every single day people are coming up with new functionalities in their AI systems, right? So some of the advice or recommendations given for responsible AI include ethical and legal compliance, to make sure that there are certain legal requirements that are adhered to, all right? Make sure that there's fairness, and also there's proper data bias. So there's some form of transparency and there's some form of explainability in our AI development. So what we are saying is that the fact that you can build an AI technology does not mean that you should always necessarily build it. It depends on the sort of impact that will bring to you or to other people. So that if I know that I can build autonomous flying drones that and then probably put some explosives in them and then target certain people, I know that, okay, I know what tools I can use, I can build that, but that doesn't mean that I should actually go ahead and build that. So we should be responsible in the way we develop any of these systems in AI. Accountability and governance. So, well, like Ama said earlier, especially in Ghana, we do not really have regulation specifically for AI, if you're looking at the wording, but the Data Protection Act talks about how you use somebody's data, what legal implications are there for using somebody's data, invading somebody's privacy and all that. So all these form part of what the responsible AI is. All right, so social impact assessment, all right? Responsible AI considers the potential society's impact of AI deployment. So this includes for evaluating potential risks, conducting impact assessment, ensuring that AI benefits are distributed equitably. All right, and also there should be continuous monitoring and improvement. So they're saying that there are upsides and downsides to AI, but also the dangers of AI need to be looked at, and also there should be ways that we can regulate how far AI can get to in terms of the kind of freedom it can have or the kind of freedom it can get. And so there's a question that should we agree that something capable of human equivalent thought should be entitled to basic rights? Are we getting to a point where we are saying that when I build a robot, we are going to start fighting for basic robotic rights? Because now they have reached a point where they are doing things that will require a certain amount of human intelligence. So they're actually there to help us. They're actually there to do the things that we would normally require some intelligence to do. So do we start fighting for rights for them? Well, this is a question I'm actually putting out to everybody here. And so, but at the end of it all, for developers, explainable AI is important. For people that are using AI, we are looking to use AI responsibly. All right, so that was the last slide for me. I think I've actually done about 20 minutes already.
Thank you so much, Dr. Pius. So, I mean, from this wonderful presentation, I think we've learned so much. For one, we've been able to learn about the EU Artificial Intelligence Act, the fact that it considers not only people who are making AI, but also the people who are using AI, and that it seeks to apply as much as possible an international law to the producers of AI systems. We've been able to see the need for regulation in artificial intelligence because artificial intelligence has become generative in the sense of not only being able to produce other AI, but often having unintended or unexplained consequences. And Dr. Pius has noted for us that if you cannot explain what your AI is doing, it would be very difficult for you to get a license, or in fact, a license won't be given to you to practice or to use that AI or generate it. Dr. Pius has also taken us through responsible AI and the fact that just because you can build artificial intelligence doesn't necessarily mean you should. At all events and circumstances, you want to consider the impact of artificial intelligence, both to yourself and to others. And the goal is, apart from, positive social impact, there should be continuous monitoring and improvement. I'm sure each of our participants has also taken their own points from your presentation, Dr. Pius. So thank you so much. We will now proceed with our second speaker, that is Mr. Desmond Israel. And now, Mr. Desmond Israel, as you see him sitting there, is a renowned lawyer with a very extensive history in artificial intelligence, but I will proceed to give you the brief summary. So Mr. Desmond Israel is a lawyer. He is a data privacy and information security practitioner, specializing in cyber laws, global data privacy, open source intelligence gathering, as well as technology policy research. He has over a decade and a half of industry experience in cybersecurity across countries like Ghana, Nigeria, Sierra Leone, and Liberia. I note that Mr. Desmond is a GW Law Merit Scholar and holds an LLM in National Security and Cybersecurity from George Washington University. In addition, Mr. Desmond Israel is a fellow with the Center for Artificial Intelligence and Digital Policy in Washington, D.C. Mr. Desmond Israel will be taking us through a number of topics that will include the role of intellectual property rights in technology management, the impact of artificial intelligence on intellectual property and cybersecurity, and he may be able to touch up on a few points relating to intellectual property as regards global regulation. So, Mr. Desmond, over to you.
Thank you, Ama. Let me just share my screen and we can start. Okay, so if you can confirm that you can see my screen, that would be good. Okay, thank you. Grateful. So I started off by saying that tremendous amount of information has been given by first two speakers. Doug did a very good job on that responsible AI. And I would like to say that even with Azure fidelity to the law, these are areas that is important when you have the conversation about artificial intelligence. So I'll signpost you a bit just to give you a refresher on the synopsis for my section of the presentation, which is a bit more heavy on intellectual property. But because you've had a very good understanding of the general AI and the regulations there, that would be a very good basis for you to just follow suit. So we'll do 4 things with the conclusion. We'll look at the role. We would look at the intellectual property rights, policies, and procedures to be used. I get the understanding that it's more of a knowledge transfer, so we need to give people, chunks and relevant gold nuggets that they can apply. Especially, I know we have quite a sizable amount of lawyers on the call. Of course, we also look at AI generally from an IP point of view. So you are not looking at the AI regulations per se, even though I have a slide where I decided to just talk generally about a few things that are happening, which are connected to AI and intellectual property. And then I'll look at what you might consider my favorite area because of my background in cybersecurity. I've more looked at AI from a security and data privacy point of view than somebody who is looking at it more from the developer implementer point of view. I always want to find problem with things and question them. I don't know if it's a good thing or a bad thing. Then we'll wrap up with a conclusion. So the way I structured my slides is to give you more like graphical representation in terms of flowcharts. And then I have descriptive text, but I'm not going to go into the descriptive text unless it's very necessary. But because I intend to share the slides, that's why I added the descriptive text so that if somebody was not necessarily on the call and still sees the slide, he might understand what is behind it. So let's start off first with the role of IP in technology management, and then we'll proceed with the AI, which will start from the 3rd and the 4th points. Now, on the first part, you just need to understand why intellectual property is relevant in today's environment about technology management, whether from software development, whether you are the one developing the electronic cars, whatever technology you are involved in, from cloud all the way to legacy applications. I wonder if they even still exist. You still need to have some sort of intellectual property management in your environment. Now, 4 things are going to happen. If you put your IPR right, and IPR here is intellectual property rights, so I'll just keep repeating IPR so that I don't run with a mouthful of repeating intellectual property rights. So if you have your IPR properly instituted, you're actually providing some sort of legal protection to your inventions. I don't know how many of you know about startups from Facebook to Microsoft fighting over who did what, who owns what. If you have your IPR established, especially for startup companies that are dealing a lot with tech, in our environment today, especially in Ghana, you're talking about a lot of fintech companies coming up with, a lot of software-based financial solutions. There's also the agri-tech guys, there's the edu-tech guys. And if you're really within that environment, you know how they struggle to claim ownership, of code. So if you have a proper IPR in your environment, key thing that you achieve is you offer yourself some sort of legal protection for all the work that you do, be it inventions, be it designs, be it trademarks, be it creative work, anything that you do, so long as you have your intellectual property rights instituted, you are providing protection for it. Another thing that IPR also does is it sort of brings in some, it incentivizes innovation, or let me say, bring in some sort of opportunity for people to continue spending time in the lab trying to come out with stuff. And it clearly fosters some sort of economic growth. Throw it back to the fintech space. There are a lot of fintechs coming up now. Why? Because they're finding ways to solve financial issues, inclusion. Let's get someone to be able to send money over a mobile network. Let's get someone to be able to buy his insurance. These are developments. These are technology-based developments that, allow people to come out, solve problems. It fosters that entrepreneurship environment that you're looking for, and of course, enhances economic growth. Third and fourth point, facilitate technology transfer, okay? Collaboration and licensing agreements. So Doc mentioned, for instance, about the API. One of the issues why the non-use of API under the EU Act is a big deal. It has to do with access to technology, the technology transfer, the collaboration, And clearly, if someone gives you access to their API, it doesn't mean you own it, but it gives you access to be able to use it, for certain outcomes. And that is because of intellectual property, how intellectual property is protected. So you have open source licenses, you have proprietary licenses, which gives you different level of access. And all of them are treated under the law of intellectual property. And then finally, create some sort of essential safeguards for companies when it comes to maintaining their competitive edge. How many of you are using Apple? You flex with it, and I'm using the term as it comes. Yeah, this is Apple. This is for the chosen few. If Apple should have released as base code like Android did, Apple is not going to be as proprietary as it is. I can see Doc smiling on that. It's not going to be as proprietary as it is now. But clearly, that is what intellectual property brings to the table. So to answer that first question and go away with these 4 nuggets on the first question, if you talk about intellectual property rights, when technology is involved, you are looking at providing legal safeguards to your inventions, your innovations. You are looking at incentivizing an environment, an ecosystem for innovation. You are looking at helping build economy. You are looking at protecting companies by the investment that they put in these sort of developments. So we'll skip up to the next point. And I have here, let me just move, I have one of the screens blocking me. Okay, all right. So this is the next takeaway we need to work with, or this is the next question we need to address, which essentially is the sort of policies and procedures you want to see when it comes to technology management. So now you know what IPR would do for you. So the question is, how do I actually implement this? How do I actually put it on the ground? What do I have to do? And I think, like I said earlier, those are questions bothering people, like what is the practicality of what you're saying? Can I get these things implemented? So before we get into the whole ChatGPT side of IPR and the conversations around the law, I just want you to soak this in a bit. It has some textual information on the other slides to support each of the boxes. But clearly, what I'm showing you here is you start off from the top. You need a clear intellectual property policy within your environment, whether it's a company, whether it's a government institution, whether it's a research lab, wherever you are, you need a proper IPR policy, which essentially states the kinds of developments that you are doing, what governs those development, and how it's supposed to be done. The next point of call is inventorship and assignment agreements. These are relevant, especially when you are not dealing with employees. Now, IPR laws, when it comes to employees, automatically gives the property rights in any intellectual development to the employer, right? Unless otherwise stated. But if you're dealing with consultants and contractors who are not your employees, you're looking at a situation where you need to be clear that upon development of these solutions, who does it belong to? And needless to say, there's been myriad of issues where people develop solutions, maybe they don't get paid, and then all of a sudden you start to get all these pushback about, I'm not releasing the code to you, I'm not giving you access to the Git repository, I'm not giving you access to the database, I'm shutting down the, you get all sorts of issues. And this is because the developer thinks that by virtue of developing it as a consultant, they own the intellectual property right. Now, the company or the institution that calls for this development is also thinking about the fact that, hey, I paid for it or I requested for it, so it's for me. But it doesn't work like that. It doesn't work like that, especially when it has to do with a consultant-contractor relationship. It's different when it's an employee-employer relationship. So you need to look at, inventorship and assignment agreements. Some of them can be very complex, with a few that I've looked at even from research and some work that I did before I left Ghana. You need to look at what exactly is going to go into these documents. Another document that is randomly used, and I use the term randomly as advisedly because a lot of people just throw it out there. That's the CNDA, confidentiality and non-disclosure agreements. As soon as a conversation starts, can we sign an NDA? Believe you me, it's the most important piece of document relevant in technology management, because the thing is, intellectual property does not protect ideas. Sorry to burst the bubble. If you are not a lawyer and you're on the call, or maybe you're a lawyer, but you don't practice within the tech space, the laws do not protect ideas. The laws protect the work, okay? So what you do with the NDA is to protect the idea by contract. That's how smart you get with these sort of things. You're protecting the idea with a contract, with an agreement, because agreements are mutually done and they are enforceable. But if that did not happen and it's just an idea between two parties and one decides to proceed with it, he's not bound by any intellectual property, right? If it is an idea, it has to be a work. That is when it can be protected. And then you have the regular IP audits. Very, very important. I'll give you a practical example and I'll be very brief about it. So I was consulting for a firm in Sierra Leone, very, let's say, African-wide firm, because they are almost in about 6 or 7 countries in Africa. And one day I received a cease and desist, and then a notice for claim from Universal Pictures. If you know Universal Pictures, you know that I'm in trouble. That's a global giant when it comes to movies. Now, what has happened? Universal Pictures is using what they call an IP agent, Echelon. Those of you interested in research can look for that organization or solution, Echelon. Echelon uses monitors over the internet, and I want to believe it's an AI-powered thing. What it does is goes around the internet on torrent sites and illegit forums where there is piracy of these movies, and then it tries to pick up some footprints. Now, Echelon picked up a footprint in Nigeria on a public IP address, and then went to the service provider who owns a public IP address, who found out that that IP address belongs to my clients who has a base in Nigeria. Now, when we received the request, of course, I'm a technical person by profile, you know that already. We did a bit of network audit and find out that on a Sunday, a staff had torrent installed on his laptop, went to the office on a Sunday and downloaded a movie called Rambo when the movie has just been released by Universal Pictures. So that is a practical way by which you can do an IP audit, intellectual property audit, a regular one, using technology, AI-powered, machine learning-powered, or you can follow an administrative process of doing so. It's quite tedious if you want to use administrative process, but something you can do. You can also look at your patent and trademark strategy, like how do you file patents? How do you check infringements of patents or trademarks? How do you monitor? You need to have a strategy for these patents and trademarks. Everything here deals with everything under intellectual property rights. Okay, so copyrights, patents, trademarks. But maybe you are not into inventions, you are just into your software development. So maybe you're more looking at copyright issues. Then some of these things might not apply to you. I'm just throwing it in there so that we don't get confused that we have to do everything that is there. This is a bird's eye view of how things should be. Then we need licensing and technology transfer agreements. Let me throw it back to the state of Ghana. How many times haven't you heard about consultants taking us off the grid when it comes to certain, softwares that they develop for us? I'll give you a very recent example. Remember the Electoral Commission? I'm sure you heard in the news about one service provider. We are not here to mention names, but about one service provider who decided that they were not going to give access to the Electoral Commission on this platform for our database, electoral database and all that. These are the problems when you decide not to pay attention to, the pre-contractual issues, getting the licensing, the technology transfer agreements properly instituted so you know who owns what. When technology is involved, it's a very dicey situation, and that's why you need some of these safeguards. And then you can look at how you want to enforce the breaches or some of the red flags that comes from your auditing. Do you want to litigate? Is it under a certain contract? If it's under a certain contract and, for instance, arbitration is mentioned in there, then you might have to go to arbitration before you end up in a court, right? Your matter will not be ripe for court unless you go to arbitration, and maybe you are not satisfied with the arbitral award. You can also look at the provisions of the law itself. Specifically, in some jurisdictions, you need to go to the Copyright Office to have an administrative hearing. If you don't do that and you proceed to court, you'll be thrown back to go for the administrative hearing. So you just need to look at your enforcement and litigation strategy. So someone might be wondering, oh, what happened to you and your client? Now, Universal Pictures wanted us, of course, there were options, we needed to desist. And so we need to make sure that we've done that and provide them evidence that we've done that, and then wrote back to them. So we ended up more in a settlement, and my client didn't have to be slapped with major fines from copyright offices and lawsuits. Let me just say we're lucky to get away with that, maybe because of how we approached it as well. And so that's some of the things you also need to align with. Of course, education and training, which I would say my clients had lacked at the time. Even though they had policies about how the network should be used, there were not policies specifically dealing with access to intellectual property rights. Of course, it wouldn't even occur to them because they are more of a reinsurance related company more than the software development company. So who is going to talk about intellectual property rights in training? But I'm telling you on this call, whether as lawyers or as researchers or as developers or as solution providers, these are areas that you need to focus on. Technology has gotten to the point where if you don't infuse it in your training for your staff, your clients, your agents, and your third parties, you're actually running a big risk. Lawsuits that are coming through technology-based infringements are in huge sums. I'm sure you saw the figures when Doc presented that for the EU. Now, if the EU gets its way, like it did with the GDPR, believe you me, those fines are not going to be just on the drawing board. They are going to be fines enforceable within the courts. And if you understand the enforceability of foreign judgments, you also know that it is possible that if you breach here and someone gets judgment in Germany and they have that committee with the Ghanaian jurisdiction, they could come and enforce it within the Ghanaian jurisdiction. The last 2 points, staying updated and of course, going into collaboration and partnerships. Again, I would use the API example again. You can develop the LLM all on your own, right? Large language modules. Look, the processing power behind these things are not for faint hearts. They are huge investments. The best way you can get in there is to get the access to these APIs, plug on them, and then build your tool to feed into these models. These things are consuming big data on the fly. They are consuming petabytes of data, and it's coming from all sorts of places, and they need huge processing powers, huge investment into their security environment and stuff like that. So collaboration and partnership is a way by which you can also look at effectively managing, effective technology management in your environment. We will not waste effort to go through the slides, the text, because like I said, the purpose is for your reading. So I'm just going to deal with some current issues that are happening. So the first one has been dealt with extensively, which has to do with both policymakers and legal practitioners are looking at, the concept of ethics and rights-based approaches to artificial intelligence. This is relevant, really, really relevant, because look, you speak about liability. I mean, as a lawyer, what I do when I enter the courtroom, what I do even when I do my legal research is to find out where there's a liability, where does the buck stops, where does the liability stop, who is going to pay for this damage. So we've had the ethics principle around, it's mentioned already. I mean, under everything that was said under the responsible AI is actually what you needed to know. So accountability, human-centered processing, fairness, non-biased processing, all these are the current relevant conversations going on across the world. I'm entering into my AI side of the presentation, so I'm starting with this. Now, OECD principles, you can look for that. There's a G20, which was also in 2016, if I'm not mistaken. The White House itself has its own AI blueprint, which they published last year. We were in school when it was published. There's a Montreal Declaration, also 2016, Beijing AI principles, Japan's AI white paper, EU AI Act, which has been discussed with you already. And then my favorite, which happened recently, is that the African Commission on Human Rights and on Human and People's Rights also passed a resolution 473. What does it mean? They are saying that whilst Africa wants to consider the use of AI, Africa must pay attention to the human rights component of it. Essentially, all that they are saying is let it be ethical, let it be right-based. And I think that it sums up what the environment is. Let's move into some few issues. Now, there was an anonymous case against Microsoft, GitHub Copilot, and OpenAI in the US here. It was recently decided. So it's a 2023 case. Now, the application from the anonymous persons was dismissed in part. Now, the part that was upheld was the anonymity of the suit, because Microsoft and these other defendants were arguing that if you are anonymous under the rules, you cannot assert any sort of standing, before the courts. But the court said that because the parties were able to prove that their lives were, in danger, the anonymity will be upheld, and therefore the court proceeded to hear the matter. But they dismissed the issues because they said there was no copyright violation of the work. Now, what was the plaintiffs looking for? Plaintiffs are saying that on GitHub, and if you don't know GitHub, see it as a container, okay, over the internet. See it as a big cauldron, a big barrel. All of us will go and dump our paperwork into it, right? So in that context, look at it as a place that developers, software developers, researchers, writers go and keep their information for public access. Now, this repository is called GitHub. Microsoft bought GitHub, and Microsoft fused GitHub with OpenAI, so that now a lot of codes over the years have been put into GitHub. So with OpenAI, we could spill out code snippets for you. We can actually write a complete code for you. Now, the plaintiffs are saying that the Copilot solution is violating the open source licenses, and it's not giving them credit to show that this is their work. The court was very, very simple on that. I'm sure questions will come and I'll address it. But the court was very simple with its answer. It says that for you to assert any damage in intellectual property, right, you need to prove the damage. It is not enough to make it anticipatory that because you have these code snippets, is it possible that your code, which is part of the system, could be regurgitated and you are not going to get credit for it, and it would violate the license. So the court refused. I wanted you to understand that part of it so we don't get it twisted. The court refused on that basis. And for a lawyer, I thought it was very legitimate, or it will open the floodgates for everybody to go and sue and say, oh, ChatGPT is likely to puke my CV out, so I'm coming for damages. It could create a lot of problems. Another one that you also need to know is Stephen Talley versus Vidal. Vidal is the head of the US Patent Office. He also sued for patent, which was, he sued for what he considered an invention generated by artificial intelligence. The court was very simple in their answer. They said that under the copyright laws of the United States, it is only humans who can invent. This is a huge conversation. I know, don't beat me for it. It is the courts that made this determination. That is the existing law. So he could not get it. Now, I'll tell you what, Stephen moved to about 6 different countries, including South Africa. Now, all the other 5 countries in Europe did not get it because they were possibly offering the same position in the law. But in South Africa, he got to register it. And I would like you to know that twist. The South African law did not require an investigation into the creation of the patent. The South African law is purely administrative. You fill the document, you present it, it's justified, they give you the patent. And that is why it worked in South Africa. So if South Africa had a law that required a patent investigation, Steve would still have a problem getting the patent done. And I'm still talking about AI solutions. Everything I'm discussing here is AI. Then there's the Zaya of Dan. Zaya of Dan is a comic. A Russian lady applied to the USCO, which is the US Copyright Office, for protection of an AI-generated comic. The administrative office refused it because they said the protection of AI copyright AI-generated content cannot be copyrighted. It has to be human-generated content. So you see, the legal issues are now bringing you into certain practical issues about why, if I use AI to generate something, why shouldn't it be copyrighted? I'll address it as I go forward. The last part you need to know is there's a lot of policy-making advocacy, lots of it. Currently, under the, I think in Harvard Law, there's one department that has done a work on it. If I find it before the event ends, I'll share the link, but they've done some work and there are over 60 AI, responsible AI-based documents from collaborations from academia, industry, countries, regional, all together trying to address this issue. Now, on the advocacy front, of course, I can't go without mentioning the institution that helped me advance the knowledge in the space. CIDP is doing some work in there. They are currently before Congress on the issue of the OpenAI that was brought. Doc mentioned what has been done by CIDP is to file a complaint before the Federal Trade Commission, getting the Federal Trade Commission to give ruling on the appropriateness of ChatGPT and its related cohorts. So this is what is happening within the space. I chose to go through this direction because my 2 previous speakers have done very good job giving you the foundation. So let's move on from there. So on the third part, and then we'll take on the last one and maybe move on from there. The third part is the question of give us perspective. When it comes to intellectual property and artificial intelligence, from the UK, from the US, and from a global perspective, what is happening? Well, I'll bust the bubbles. There's nothing fancy happening there. The laws are the same laws, except for a few who had passed what they call guidelines. So let's start from the UK. The UK perspective when it comes to AI-generated invention is that scientific or mathematical methods are excluded from inventions. Very simple. I love it when the courts the courts are reasoning. The courts don't want to stress, right? That doesn't mean the courts are lazy. I'm a lawyer. I know what I'm saying. A lot of work goes into coming with these decisions. But you see, the courts don't make decisions for one case. They make a decision that is going to impact generations, impact industries, open floodgates. So they are very, very extremely careful how they determine some of these matters. In the UK, the scientific or mathematical methods are excluded from inventions. And this is repeated in the UK IPO guidance on AI inventions, September 2022. But the main law that governs patents in the EU, even when AI is involved, is the Patents Act of 1977 as amended, and then the Patent Rules of 2007. Now, on the copyright side, the law that is still applying to copyright in the EU, even when AI is involved, is the Copyright Designs and Patents Act of 1988. Now, look at how old these acts are, right? They are open and generic in such a way that as technologies evolve, they find a way to clip them in, right? But we need to have a conversation whether we should be having IP AI-based laws. Now, I did a paper for my LLM, even though it was in national security and cybersecurity. I had a whole global privacy study, and I did a paper. My paper was actually on assessing AI, the effectiveness of cross-border data regulations in the context of AI, because I am arguing that they are not effective. Indeed, they are not. So in my paper, though it's approved, it's yet to be published. If it does, I wouldn't mind sharing. Some of you can critique it. I might get better looking at it. But essentially, I'm trying to say that with what you're seeing now, we can still have a conversation whether we should move away from some of these laws. Now, I've made the argument for and against. For, because the courts are slow in trying to affect the rights of people, right? And then against, because technology is moving very fast and we need to look at its appropriateness and bring it into the fold rather than wanting to apply like what, a text that is what, 1988? I mean, but it is working. They are making decisions based on that, and they are making very cogent decisions based on that. It's not like those decisions are bogus. They are not. Finally, it's mentioned already about the data protection. In the EU, the GDPR still applies when AI is involved. And your catch here is that personal data, if that AI doesn't deal with personal data, the GDPR will not apply. So personal data, when personal data is involved, the GDPR will apply. In the US perspective, inventions are credited to human creators. So that ends the matter. That's the US perspective. And that's what their laws have been saying since time immemorial. Title 35 of the USC, or call it the United States Code, deals with American Invents Act, right? 2011. Then under the copyright law, they have the Title 17, which is the Copyright Act of 1976. And then recently they added the Digital Millennium Copyright Act. It is under this act that the Microsoft Copilot case was filed. And then Section 107 of the Copyright Act deals with what they call fair use. The United States is not very big on data privacy from that human rights global perspective. No, I took time to study that system. It was part of one of my requirements. So I think I'm well placed to tell you that they are not big in data privacy when it comes to human rights of it. It's a capitalist state. They are more into the economy of things. So they are very careful with passing laws that affects the committee of economy, right? They are looking at trying to push commerce. So here, rather than in the UK, so that's one of the differentiators you can see. Rather than in the UK where the data protection seems to form a base, the fair use rather forms a base here. And then finally, from a global perspective, you're looking at international treaties. Currently, you can look at the Patent Cooperation Treaty and the Berne Convention, of course, and there's also the efforts to harmonize. So in the global perspective is the balancing of the human intervention and then the AI creation. That's where we are coming from now. Can we find a way to balance, that human invention with the AI creation so that we can give AI some credit? It will take us a very long while to get there. If you know how international peace works, that's a joke. If you know how international peace works, then you know that it's going to take us some time to get there. And then, of course, on the last part is the ethical and the legal considerations. Reference is made to the 4th session of WIPO conversation. There's the recommendation paper on the ethics of AI. But I can tell you, it has almost everything that my co-panelists did earlier, Doc did earlier with the responsible AI. It pretty much says the same thing in a different context. So I would proceed with the last part of my presentation, which is the impact on artificial intelligence. The impact of artificial intelligence on IP and cybersecurity. Again, I'm giving you a more graphical representation to help you grasp it. So the first part is you can talk about IP creation and protection. Okay, that's one impact. Under that, there are 2 issues: AI-generated inventions and then the copyright challenges that it comes with. Similar to things that has been discussed earlier. So I would not need to belabor the point unless you have a specific question there. I wouldn't mind addressing it. The other part is when you talk about IP enforcement and infringement, right? And 2 issues happen there. One, there can be automated infringement of intellectual property rights. Look at the Copilot case that I'm talking about, for instance. People putting their code into GitHub. The code is being regurgitated to other people who want to write code. Plaintiff says that no, it's an infringement. It's an automated infringement, and the court says that no, you need to show that you actually, endure the damage, or your code has actually been regurgitated out. It can't be anticipatory. So that's an automated infringement. And then you have AI in enforcement. Remember the echelon example I gave you with my client? That is AI in enforcement, where AI is used to determine IP breaches and to ensure enforcement of it. The cybersecurity side, you have the cybersecurity risk, okay? So AI itself is susceptible to adversarial attacks. Now, I did a bit of research around the security component of AI, not a main paper, but it gave me an exposure into it, especially because I do practice cybersecurity as a technical person. There's what they call the data dive vulnerability or the input vulnerability. Now, that is when you can inject bad data sets, right, into the AI, because the AI is trained with data sets. Just in case you don't know, or maybe you've not been able to grasp it, because Doc did a very good explanation, but just in case you didn't grasp it, I think Ama also did an explanation. The whole issue of these AIs, input, processing, output, computing. At the processing side is the black box that was mentioned. That is where the algorithmic work happens. That is where the data is looked at and make certain determinations out of it. And of course, because AI has autonomy, you don't expect the same output. You are allowing AI to make a determination of that output. And what I'm saying is this: there's a vulnerability where attackers can inject the input with the bad data. So AI can either be biased or malfunction. And it's proven in the lab. Maybe we've not seen it in the wild, but it's proven in the lab. Some Harvard papers have this. I wouldn't mind sharing some of these things in a later date. So adversarial attacks is possible on AI. AI has huge privacy concerns, large data sets. AI already violates data minimization. And I mean, I'm ready for that conversation any day. AI already by design violates data minimization. It takes so much just so he could have enough to process. But if you look at the key principle of data privacy, including global data privacy and local data privacy in Ghana, data minimization is one of the key things that we look at. You can't take more than you need. AI will take everything it needs, okay? Once it is trained and put out in the wild or even in a lab, it could take excess data to do its work. And so that brings huge privacy concerns issues. And then we have AI in cybersecurity, where the AI actually forms the basis of cybersecurity tools, threat detection, vulnerability assessment. Even now, we are using AI to do what we call penetration testing, where AI automatically finds a vulnerability, writes a code to exploit, right? And then tells you if it's possible for an attacker to exploit your environment. So that's a good thing. So the impact that I'm addressing here is both the good, the bad, and the evil. And then you have ethical considerations, which has also been touched on. I don't need to belabor that point, but bias and discrimination, and also currently a subject of study, which is called intellectual property ethics. And so these are some of the issues that we're dealing with when it comes to the impact. In conclusion, what do I have to say? I personally think that this should take a multidisciplinary approach, okay? We can have lawyers sitting somewhere else doing their own thing. We can have policymakers sitting somewhere else doing their own thing. We can have industry sitting somewhere else doing their own thing. If you study the space, and you study it very well, you would agree that you need a multidisciplinary approach to deal with the issue like once and for all, or to curb it such that we will be comfortable. Because look, AI is delivering on the job. It is. But the fear is the risk that we are running on the side. So if it is the risk, why don't we come together from developers, policymakers, the legal people to address it? And we address the legal frameworks, we address the ethical considerations, we address the technical safeguards. I also think that is not going to be a one-stop thing. You know why? It is technology. It is technology. It's not going to end. ChatGPT already has a version 4, right? So we're going to have an ongoing dialogue. So I think that that ongoing dialogue must be set where all the parties are having that ongoing dialogue until we get to maybe the point where we know that, okay, at this point, maybe we're on autopilot. I don't know when that day would come, but my gut feeling with my understanding of the space is that it has to be an ongoing dialogue, and you need everybody involved. Like not a single stakeholder should draw because they feel different. No, this is something that is going to affect humanity, and everybody must pay attention to it. In summary, the collaboration is still important. We have to develop the appropriate regulations. We need to get the best practices. Of course, that's the only way we'll be able to navigate the space. So that brings me up to the end of the presentation. And when it's time for questions, I'll be open for them. Thank you. I think you're muted.
Thank you. Wow. So thank you, Mr. Desmond. I think we can all agree that this has been an excellent presentation. Just to our attendees, kindly note that there will be a question and answer session. So if you have any questions, you can go ahead and put it in the question and answer box or section of the webinar. And when we get to our question and answer session, we'll proceed to deal with those questions as best as we can. I will now proceed to introduce our final speaker, Mr. Tony Marfo. Tony is an artificial intelligence expert as well, because who on this panel is not? He is a tech entrepreneur who has keen interest in software development, artificial intelligence, robotics, and agri-tech. Mr. Tony Marfo holds a master's in artificial intelligence from Nexford University and a Bachelor of Science degree in molecular biology and biotechnology from the University of Cape Coast, as well as a software entrepreneurship diploma from the Meltwater Entrepreneurial School of Technology. As a Chief Executive Officer of AnyTrack, Tony's role involves leading and researching the best technologies suitable for the scalability of AnyTrack and building various solutions. We note that Tony has written and published more than 20 articles in both local and international websites, and has contributed to online news websites within Africa and around the world. Mr. Tony Marfo will now proceed to take us through the question of how we as lawyers can best use artificial intelligence to maximize our practices. Mr. Tony Marfo, kindly take it away.
All right. Thank you, guys. I think most of the job has been done by the previous speakers, such amazing presentations by Doc and Desmond, Ama as well. Yeah, so it's really nice to be here, trying to listening to what everybody else in the industry, especially in this law firm, or basically the law industry has to think or say about artificial intelligence. And it's nice. It looks like AI is really not going anywhere, and I'm really thankful to be part of this presentation. So I'm basically talking about artificial intelligence and the modern law firm, basically how artificial intelligence is going to improve the legal practice. I have a very short presentation, so I won't bore you out so much. I know we're very much not in good terms with time, so I'll just share my screen briefly, and let me know if you can just see. I check.
Yeah, I can see it.
All right, cool. Okay, so I think I was doing a presentation quite recently for CENDLOS, which is the Center for National Learning and Distance Education, as well as open schooling, more like the IT wing of Ghana Education Service recently. And basically we're talking about artificial intelligence, machine learning, and it was a bit surprising to understand from other people's, maybe non-tech savvy people's perspective, what basically artificial intelligence was. So I just wanted to do a very quick introduction of what artificial intelligence is. I think the previous speakers have done like really good jobs about it, but I'll just quickly brush through and then go through basically what I have to. And then I'll just talk about the benefits of AI, as pertaining to the legal industry. I mean, it's quite broad, and AI is basically affecting all industries, including AI itself. And yeah, I'll just give a short description about all those, as well as maybe one or two case studies. So I think when I asked most people during the presentation at Semlos what they thought AI was, it was a little surprising to me, but basically what we ended up just talking about was the fact that it was just a broad field in software engineering or computer science, which basically deals with tasks that are going to be performed that are, basically human-like in nature, right? And this basically means we having algorithms, or should I say methods that the computer understands mostly to be able to, replicate tasks that, normal human beings or normal logic pertaining to humans would be able to, go through. So something like perception, like computer vision, as mentioned earlier, natural language processing, etc. And the fact that, machine learning, as a field, or artificial intelligence as a field, could be applied to, like most industries, including AI itself, and then the legal aspects. So there was one other a very interesting thing I learned that was basically what was not AI, because most of the time when we asked the audience what AI was, most people were thinking, the iRobot age, where Ama mentioned. I don't know. There is like this sort of argument around if it's even going to get there, the sentient nature of AI and everything else. But as far as we are concerned right now, AI is not robots taking over as one of the answers that we got, or we came to understand from the audience. Most people were thinking AI was just, as we could see in the Terminator movie, where like machines from Skynet were just killing people everywhere and then, taking over basically. And one other thing that we also came up with, or we understood that was not AI, was the fact that AI was not basic automation. So currently in computer programming or development, software engineering, whatever, we have basic automation tasks, right? So something like, maybe I have like a couple of servers, a server farm that I'm managing. So something like getting automated notifications as to whether my server is up or is down, or probably, having issues with memory or storage, had basically nothing to do with AI. It's not AI per se. So if you are just, behind a laptop or behind your phone, and you get some automated repetitive tasks that are, sent to you. So for example, if I think Apple right now, they introduced this shortcuts app where basically you could just use to program your own iPhone. So I have this automation where if my battery is below like a certain percentage, it can easily tell me that, hey, you need to charge your battery, because I know I'm very bad at charging my battery. Everybody around me says that. So I just put like a very small automation on that tells me that, hey, your battery is running low, so you need to charge it. Or probably if I get a text message from, or an email, I think I did that automation quite recently when I was looking forward to getting an email from one company that I was supposed to be working with. So basically, if I got an email from that company, there is some other tasks that is being performed that basically is not AI. So I just wanted to debunk that. It also has to do with traditional programming, where basically we write like a function or like a method that would take in like some particular argument. So for example, if you have a functionality on a website that does some sort of okay, I wouldn't say predictive analysis, but basically like there's this, I'll use an example that I've seen quite often. There's like an app that probably will take your age or your name and then tells you that it looks like you will not be in love or something, or some very funny thing like that. That is not AI. So I just wanted to draw that line, even though I know most of my speakers have done that. And I'll just go on to talk about, strictly talk about like the benefits of artificial intelligence as we've known what it is or what it's not in regards to the legal industry. So like I think I mentioned earlier, AI affects almost all industries. I use almost because there are still greenfield industries that are not really yet settled. One of them, well, not so greenfield, but blockchain, which is something that is being merged with AI at some points, which I'll talk about in one of the case studies. But artificial intelligence has a lot of benefits that cut across, but most of the ones that I want to just tap on with regards to the legal industry basically has to do with research and all these basic things, or let's say these benefits that I have written down. I have like 1 or 2 case studies that I'll talk about in the next slide, so I can just show them. So in terms of research, there is a company that is doing something with this, more like a search engine for legal firms, which basically help lawyers to do a lot of research only pertaining to what their legal industry, right? So they basically built like a framework around the language, the models that we have, that is geared towards research only for law, right? So things like legal documents, statutes, like everything else that has to do with law and research, is one of the benefits that artificial intelligence offers to the industry at the moment. So in terms of filing, so there is another company that is really doing some exploits with that. I'll share the details in the next slide, which basically provides like search engine capabilities as well, similar to what the other company does. But this has to do with like just focusing on risks of reducing errors and falsifications of evidence and those other stuff. And the fact that it provides a lot of time-saving opportunities for lawyers, because most of the time lawyers would have like a lot of data to go through, and being able to track where what case is, or at what points a case is at a particular point in time, can probably be a very daunting task. I'm not a lawyer, or I'm not very well versed in the law terms and everything else, but this is most of the benefits when we're talking about how AI impacts the law. So there's due diligence as well as predictive analysis, which I was talking about earlier on, and client communication and content writing. So this, I'll just skip over to some of the platforms that I was interacting with earlier. I tried out some of their systems. Most of them are basically inheriting under OpenAI, like more of the Da Vinci models and some of the other very powerful models written in Python, basically. But Kira Systems is basically doing something with smart contracting, which is kind of merging like the blockchain with like OpenAI or AI, just to help lawyers and the law in the law or the legal industry do things with contracts. So they get things like legal frameworks around like a contract, things with the content, basically everything that has to do with contracting or contracts when it comes to the legal side of things. and moving or migrating them to like a blockchain is what Kira is focused on. And one other company that I want to talk about was Ross. Ross is basically also doing something with search engine optimization or search engine, which just has to do with the legal industry. So I think IBM was sponsoring this project, and I think I'll share some of the links later. You can check it out. Luminance is also doing something with due diligence for most of the companies. I think there was a startup in Africa, maybe I wouldn't want to mention their name, that was in which case Luminance was used for their due diligence. And basically you're just trying to extract data and then see how these risks of, like, as in for investors, the risks of investing in such a business as per maybe their returns and everything else was going to be. And then there's also Neuta Logic, which is basically an AI as a service. So what basically Neuta was or is doing is also providing artificial intelligence framework as a service, basically. So you are a law firm or like a legal entity that wants to provide or spin up your own artificial intelligence application, basically. Neuta would basically provide you a service or an AI as a service instance that, you know, kind of will let you build your own application. And it could basically be anything that you want to build. And it depends on whatever subscription that you are signed on to. So some of the challenges that I came across, or I think would be an issue of concern, I think is something that most the previous speakers have spoken about earlier, but the most important thing is cost. As much as it is for people to just go behind their machine, easy for people to go behind their machine and just open an account with ChatGPT or OpenAI and then start typing forms like, hello, can you do my assignment for me? And then it spits up everything for you. Just copy and then go and paste. It's not an easy thing to implement and develop, right? So as all these artificial intelligence acts coming up that was spoken about by the previous speakers are going to be regulated. Like, you realize that most people would have to move, or most huge companies would have to move from depending on like interfaces or interfacing with other companies to, you know, starting to develop their own thing. And for something like a legal firm, I feel like most of the data that you are going to be working with probably has to be something that needs a lot of protection, right? So you're going to have to figure out, you know, having to design or build your own models that are going to be used by you and only you, basically. And that could prove like a very expensive thing, because in Ghana, one of the things that is, I think, would be limiting for us to even start something like this is the lack of our own government data centers, which is something that was recorded in one of the books written by one of these. I think I think I'll just get the name for you. I think it had to do with governance and the artificial intelligence. It's a book that was recently released and you know, auditioned earlier on Joy FM. So, you know, going forward, like, if you're going to have to be dependent on some other interface or application that provides you with like endpoints to do something like, you know, data analysis or predictive things for your cases and everything else, you would possibly want to be looking at, you know, designing your own, and it can be very expensive. The complexity also is there. and complexity in terms of building as well as maintaining the application. The data privacy, which is what I've just touched on basically, and also biasness and falsification. So I think Doc spoke about deepfakes in his presentation, and I watched one, I don't know if it was a documentary or like a video, just a video, the random video that spun up recently on the internet, where people were basically mimicking. A deepfake basically means like you're mimicking someone else's identity. And it was quite a serious thing. And I'm just looking at it from the perspective of evidence and, cause of, something. If, for example, I appeared to you on the call as Obama or any other thing, which is possible, by the way, in this age, it would sort of send out like a lot of reputational vibes to people that, hey, Obama is on this call, in which case maybe I'm not, and it could cause a lot of issues or problems for the organization that maybe I may be working with, right? So it's one of the things that I feel like would be like a real challenge to most legal entities or industries. So just a quick run through. One of the important things I wanted to talk about in conclusion was the fact that even though we are thinking about AI as a supportive structure or like a beneficial thing to most industries, including the legal firm, I don't think that it's going to be a very good thing to totally replace your profession, if so to speak, with whatever AI tools or applications that are going to be used, because the level of judgment it has is basically a mirror of whatever data that it has been given. And if you're looking at AI in general, it's basically, like we said, chunking out large data sets, learning from them, and then giving like a chimera of like information that it just thinks is right or is in some perspective, which might not be exactly correct in terms of specificity and interpretation, so it would be a very good augmentative tool, but I think that care should be taken in terms of letting it more like supersede or overtake the entire just the entire process of the whole legal firm, in order to avoid like wrongful judgment of cases and everything else. So that's just the little thing that I wanted to talk about in terms of the benefits. I didn't want to take so much time also because I think we're already out. And so, yeah, I'll leave it here if there are any questions with regards to that end. Thank you.
Okay. Thank you so much, Tony. That was a wonderful presentation. I think that we've all walked away with certain key insights. Overall, it seems that we've had a very excellent time on this webinar. From Dr. Pius Gadosi, we learned about the EU Act and the differences in regulation between the EU and the US, as well as the need for regulation and the responsible use of AI. Mr. Desmond Israel provided us those 4 key nuggets on intellectual property rights and how they allow us to protect our works, as well as create and incentivize innovation, foster economic growth, and protect company investments. He also noted the need for an NDA, that is a non-disclosure agreement, being that intellectual property only protects the idea, or actually intellectual property doesn't protect the idea, it protects the work. So the NDA is what you use to protect your idea by virtue of contract. Mr. Desmond also noted the need for a multidisciplinary approach in engaging in an ongoing dialogue in dealing with the various issues that artificial intelligence brings. Mr. Tony wrapped us off with a wonderful presentation on how law firms can maximize the use of AI. And he has noted that apart from helping with research, contracts, and due diligence, there are actually various use cases whereby systems such as Kira systems, Ross Intelligence, and Luminescence have been adopted by perhaps various institutes and employed to increase the efficiency of their, their law firms and their workings. We were also we've gone over the challenges involved in artificial intelligence, the benefits of artificial intelligence, and the fact that no matter what, artificial intelligence cannot yet replace lawyers. I think that's a nice place to end by the end of this webinar. So that being said, we are going to have a very quick question and answer session with our final, let's say 5 to 10 minutes. I noticed that we have quite a few questions on the Q&A panel. We'll see about taking maybe 3 and look at how time goes for us. I note that Mr. Pius and Mr. Desmond have answered some questions as well. So just in case perhaps you have a question, you could have a look at the question and answer panel to see if your question has been answered in text instead of in video. So let me just go ahead and open up the Q&A panel and let's take the first question. Okay, so I'm just going to go ahead and read out this first question from Frank Mensa. This is to Mr. Israel and Dr. Gadosi. You both mentioned biases in artificial intelligence. Considering how less involved Africa is in research and development of artificial intelligence, Frank Mensa wants to know how could such biases in AI systems be perpetuated, amplified, or mitigated? How do we achieve fairness, transparency, and accountability in AI algorithms and decision-making processes? I don't know, yeah.
Yeah,
Doc, you can go first.
if I may. Yeah, okay, all right, sure. Yes, you're right when you say that in Africa, we have a problem of bias, and that has to do with how we collect data, or even if we collect data at all. Now, you go into most of these academic institutions, and students actually do some research, collect data, come up with some results, and we don't see that data anywhere again. Now, our problem is, how do we streamline the process of collecting data, storing data, and making sure that we have access to it whenever we need it? Like Mr. Israel said, and that's a known fact, that data is the bloodline for AI. Without data, there isn't AI, or the sort of advancements that we are seeing in AI today, we aren't going to see that. And personally, I believe that the reason why a big company like Google will set up an AI research center in Accra is because they know how to take advantage of the sort of data that is lying around that we are not taking seriously. Quite recently, actually earlier this year, we published a paper in collaboration with the AI Institute in Berlin. And if you see the chapter that I wrote, I actually wrote on data bias in Africa. And there was a recommendation that I gave that we can follow the guidelines of the FAIR principle that was published sometime in 2016 or so. Now, FAIR, if FAIR actually stands, that's FAIR, it actually stands for findable, accessible, reusable, and interoperable source of interoperable data. Now, when you're talking about findability, we are looking at a way to assign the data sets that we collect so that we assign it a globally unique identifier, right? And we enrich them with a lot of metadata so that we can index them in searchable resources. Anytime you're looking for maybe publicly available data, you can actually find them. accessibility, that's giving people the right to know who is using their data, as well as why and how their data are used, right? So we can have different forms of authentication and authorization systems as well, all right? And also, when we are talking about interoperability and reusability, then we are looking at certain characteristics that ensure that the data set can be linked with other applications for analysis. When we start doing that, then we are ensuring the security, proper use of data that is actually collected by, it doesn't matter which company comes in to collect these kinds of data that they are going to use for these AI applications. Right? And also, once we have a simple and efficient system for collecting our data, it shouldn't be very difficult to access some of these data that we use. So that if one of the very first facial recognition applications that came out, when AI, people started going into deep learning or machine learning or deeper learning, they found out that the AI application easily recognized people with white faces, and with people that had darker skin, so it became more difficult to recognize them. And so they realized that they need to collect more data of people that had darker skin, so that if I'm running facial recognition, for instance, if I'm using my phone to unlock, I'm using my face to unlock my phone, then I know that that application that has been installed onto my phone will work for me. It doesn't matter whether I am white or black, right? And that is how we have facial recognition applications that actually work very well these days. And it cuts across. It doesn't necessarily have to be computer vision alone, natural language processing as well, all the aspects of AI that we are looking at, so that AI applications that are developed will be developed for everybody. So that is what I have to say. If we are able to follow some of these principles, we should have a more efficient and secure system for our data.
I think we're on the same path. And I also add that the issue is not really about Africa. The issue is about AI itself. The biases reside in the input we place in there, and you've got very good example from Doc, but I can also give you a practical example here in the US, where there is an AI-driven platform that grants a bill application. It grants, when you file a bill application, the decision is made by an AI application from the courts. Now, algorithmic audit proved that Blacks were less to get application granted. And I know why everybody's laughing. But that was not true, you know. That was a bias, because the training data was such that a lot of these bill conditions and bill applications, whether refused or granted, were based on race, you know. And that's why the ethical AI considerations is saying that design these things such that the decision is anonymized. It is not based, or even if it's going to be based on some of these pointers, it has to be balanced so that it picks the information from all sorts of places and be able to make the determination on that. So that's just what I'm going to add to it, because I think Doc just touched it the way I would have anyway, but I'm just adding that example to it. So it's about the input. It's about how we design the AI. That is why AI governance, AI ethics, responsible AI has become the center of the conversation, that let's design systems that are less biased, if not at all.
All right, beautiful, beautiful, beautiful. I hope, Frank, that answers your question. We're just going to move on to our last and final question before we say goodbye. The question is for Mr. Israel, but of course, Dr. Pius, sorry. If you have any contributions, please feel free to make them. Mr. Tony Marfo, that goes to you as well. All right. So the question is, why don't we adopt a kind of positivist, laissez-faire approach to regulating artificial intelligence as far as data and intellectual property? We see a bit of that with social media platforms and defamation, where they curate content like publishers, but are not held to defamation standards like newspapers because it is simply impracticable to do otherwise. Perhaps we should abandon all pre-existing notions of data and intellectual property and just let the market demands shape the AI river course. In reality, it seems most people are fine trading data for more convenience. Perhaps this time Mr. Israel will start first since the question was addressed to him. Yes, so I hope you got that question, Mr.
Yeah,
Israel.
I did. Very
All
clear.
right.
So let's put the question in the context of risk. We are saying that we should take a more relaxed approach to dealing with the issues that may emanate from AI. Now, if you are familiar with Section 230 Communications Act in the United States, you would see why platform providers are not really taken into liability when issues of defamation comes up. Of course, that conversation has been stretched into other areas, and people are even thinking if Section 230 should still survive the legal text as it stands now. But the point I want to make is, it is not as though it's not regulated. Okay, it is, but in a certain context. That's why the providers have the leeway. It's a matter of law. I haven't seen our position on Ghana. I've looked at the Electronic Communications Act, Electronic Transactions Act. We do not really have something like that, but yeah, there are other provisions that protects the communication providers. For instance, especially if in the course of a crime, they are just a mere conduit. Now, I'm giving you all these examples for you to understand that the legal space already deals with assessing legal risk and protecting the environment, protecting society. So it would be very difficult to make an argument for a laissez-faire regulation or a laissez-faire approach to a technology that it started way back, but within a few years, we've seen how prevalent it could be and some of the challenges that are there. Imagine someone getting incarcerated because AI said he has to be incarcerated. Imagine an employee losing job, potential employee losing job because according to AI's assessment, that person cannot deliver on the job. Imagine again someone going for a medical treatment and gets wrongly diagnosed. So the accuracy is there, is undoubted. The accuracy is there. But again, the facts also shows that the risk exists. So all we need to do is approach it rightly, right? I would not vote for a laissez-faire approach. No, I would not, because we can see the outcomes. And your position seems to be akin to the Microsoft policy analyst approach. I mean, in the recent conference he was asked, he said that, well, let's wait for AI to cause some real harm so that we can regulate. Yes, I'm quoting him. He says, let's wait for the harm to happen before we regulate. And I'm asking myself the same questions, that is he processing similar scenarios? Like you are due to go to college, and then AI says, by virtue of the region you are coming from, a lot of people fall out from college from that region. So you might be wasting scholarship funds. So you shouldn't be thrown into college. You should, or you are going to get out anyway, because the statistics shows that people coming from your region can get out. You see, this is the decisions that AI makes because of the input we put in there. And again, we are human beings. We designed this. Don't forget. That's why it's called artificial intelligence. I mean, I know if you are giving doctor, he will probably be talking to you about all the mathematical decisions that went into before we got to the point of even accepting that there's something called artificial intelligence, the Turing test and all that. It has to do with math. It has to do with reasoning. It has to do with logic. So if I tell you that every person that enters this room in a black shirt is a potential thief, the next question you are going to ask me is, how did you know? Oh, for the past 5 years, everybody that enters that wears black takes something, right? I've prejudiced you right from the onset. So your decision about people who enter the room in black shirts is that Desmond said it is possible these people are thieves. So you categorize them as thieves. That is artificial intelligence. Large set of data. So it gets its accuracy at a certain level that, listen, if I have been trained on 10% of a 50 million volume data set, and I go into the data set, and now I have 80% accuracy on the same training data, which was 10%, it's likely AI is going to tell you what you ask it to tell you. So I am all for regulation. I am all for taking the right regulatory steps towards it. But I think I would shudder to vote for a laissez-faire. Well, maybe because of my understanding of laissez-faire, because laissez-faire essentially, and maybe he could correct me, but the way I understand it is you want us to hold back and see the things happen. Things should unfold. And as they unfold, we regulate it. You don't want to do that with AI. I would end this by giving you the example of the design of the internet. When the internet was designed, it was for efficiency, for the use. Nobody ever considered security as part of the design of the internet. Security has become such an issue. We have even built careers out of it. I have been practicing security. I mean, I'm actually in my 18th year doing security because I started very, very young, So that's the problem you are going to create when you get another technology come into the environment, and we want to take an approach of, hit the harm and then we fix it. Like the software developers will say, we'll fix the code as we go. We'll go to production. When it breaks, then we fix it. We know what has happened with people who fix production in the code in production. So that's just my very frank input on that.
Okay, thank you, Mr. Desmond. Dr. Pius, please, do you have anything you want to add?
I believe Mr. Israel, I said it all. But I also have one example for the person that has a question. It's just because I always ask this question when I get the opportunity. So during the COVID period, there were people that tested positive for COVID and that also survived. Now, if we were to decide that, okay, AI is the decision maker, and fundamentally AI is a goal-based system. Now, the goal is, all right, let's prevent the spread of COVID. Now, if everybody that tested positive, and the main goal of AI was to make sure that we were stopping the spread of COVID, what do you think the decision would be? Let's wipe all of them off the face of this earth. All right. And then let's wait for that to happen before we decide that, okay, no, we don't think that AI is a good decision maker. So it's just, if we were to say that we are not, we are not saying that we should, because we do not know exactly what limits of AI would be. We do not even know what algorithm somebody will come up with today. But what are the capabilities? If we are able to define what the expectations are, we know exactly what the expectations of the AI that we build. If that can be outlined properly, then we will not have to to be scared of the dangers that AI can bring to us.
Very well said, Dr. Pius. That example was one I will not forget. All right. So I believe that this brings us to the end of the webinar. I hope that you have all had an amazing and engaging time. I would like to say a very big thank you to all our panelists, Dr. Pius, Mr. Desmond Israel, Mr. Tony Marfo. Thank you so much for your time. And we hope that we'll be able to see you again as we host something similar to this in the future, right? I don't know if any of our panelists have any closing remarks that they would like to give before we close out the webinar.
Well, don't shy away from AI. Actually, portions of my presentation was from AI. I wanted to see if AI understands itself, and it was following my thought process. So that's just to tell you that it's the tool that is relevant to what we do. But like every other thing, it's like me telling you about internet security and showing you how all the fancy things I could do, when I have certain tools in my hands, and then it throws you off because it probably makes you paranoid, right? And you don't want to go on the internet again. No, that's not how this works. I remember doing a social media security presentation, and at the end of the presentation, I listed about 12 social media platforms that I was on. And I ended the presentation by telling them that I still enjoy myself on social media.
Duly noted. Dr. Pius, do you have any closing remarks for us?
Well, AI is here to stay. Every opportunity that you get to jump on the wagon with everybody else, just do it. If it's learning how to develop using some of the AI tools, if it's using AI to do your work efficiently, yeah, like Desmond said, don't shy away from it. Eventually, we are all going to start using everything AI. If you give it another 5 more years, literally every tool you're going to use would be an AI-based tool.
That is true. That is true. That is true. So I believe with those words of wisdom, our webinar can come to an end. Thank you all so much, our attendees who have joined us and have stayed with us throughout our webinar and our various presentations. We hope that you've had an excellent time and that you carry with you a deeper and I want to say more developed knowledge of artificial intelligence, but no fears about it. Right. Thank you so much. Thank you to our panelists, and we hope to see you all soon, sometime in the future. Thank you. Have a good afternoon.
Thank you.